Insane National Historic Preservation Act, NHPA Best Environmental Law and Case Review. United States Statute, National Historic Preservation Act, NHPA, was enacted in 1966 to preserve historical and cultural heritage by recognizing and protecting significant historical sites, buildings, structures, and objects throughout the nation. The National Historic Preservation Act, NHPA, was signed into law by President Lyndon B. Johnson on October 15, 1966. It was created in response to concerns about the rapid loss of historic buildings and cultural sites due to urban renewal, transportation projects, and other development activities. NHPA exemplifies the importance of identifying, protecting, and enhancing the nation's historic and cultural heritage for the benefit of present and future generations. NHPA is intended to avoid, minimize, or mitigate adverse impacts on historic resources. Undertakings, by definition, include effects on historic properties of any project or activity that they carry out, assist, fund, permit, license, or approve. For example, new construction, alterations, renovations, grant dollar approvals, and other actions may be considered an undertaking. Actions federally and legally enforceable under NHPA include historic property subject to federal jurisdiction and actions legally binding based on transfer, lease, ownership, or sale of property. NHPA encourages the development of comprehensive preservation plans at the federal, state, and local levels to guide historic preservation efforts and identify priorities for historic resource protection and stewardship. Smash the like button for the YouTube algorithm. National Historic Preservation Act, NHPA, provides a framework for agencies to follow for considering the potential effects of their activities on historic culturally significant resources through actions focused on preservation. Historic characteristics of structures and buildings are preserved due to the National Historic Preservation Act. The National Historic Preservation Act provides an approach to how federal agencies should approach undertakings with respect to historic preservation through consideration of impacts prior to taking actions. The undertaking or actions performed by the federal agency must not have an adverse effect on historic properties. Consultations must occur and actions to minimize, mitigate, and avoid adverse effects. The regulatory SHPO, THPO, and HPO review consultations completed by agencies and approve of actions taken to minimize, mitigate, and avoid adverse effects or deny approving of projects because of the adverse impacts they cause. Agencies cannot fund projects that are not in compliance with NHPA because if they do, they break the law and are liable for their actions. Redevelopment initiatives can no longer demolish historic and culturally listed sites without considering the impacts of this decision. There is a movement throughout the United States to maintain historic, culturally significant structures, buildings, objects, and sites designated to be protected by law. Agencies must now protect historic properties and consider the irreversible consequences of our actions on historically and culturally significant resources. The National Historic Preservation Act, NHPA, creates a process for considering the nature of effects on historically significant resources. Other cultural resource laws that foster historic preservation actions include the Antiquities Act of 1906 and the Historic Sites Act of 1935. The National Historic Preservation Act also established a fund called the Historic Preservation Fund to provide financial assistance for historic preservation projects and initiatives at the federal, state, and local levels. Be sure to slow the video speed settings if you want to watch the video in a slower pace. National Register of Historic Places. The National Historic Preservation Act, NHPA, established the National Register of Historic Places, which is a list of properties considered worthy of preservation due to their historical significance. Establishment of the National Register of Historic Places serves as the nation's official list of historic properties, districts, sites, and objects that require preservation actions due to their historically significant value. Listed places are recognized, protected, and eligible for different incentives. Eligibility for financial incentives protect against adverse effects of federally funded or licensed projects and foster preservation of historic characteristics of the listed places. NHPA establishes a framework for historic preservation and ensures actions to preserve the historic and cultural characteristics of listed National Register of Historic Places. A historic property is any district, building, structure, site, or object that is eligible for listing in the National Register of Historic Places due to significant designation listing at the national, state, or local level based on American history, architecture, archaeology, engineering, or culture. The National Register defines criteria for eligibility of a property, which includes that it must have a significant association under the criteria to be eligible for listing. Sites may be eligible for listing or listed on the National Register of Historic Places and require more detailed compliance actions. The first thing we may assess when determining eligibility for becoming listed is the age of the site being over 45 years old. Listed sites can be new construction and not over 45 years old, but if a site is over 45 years old, there becomes potential for historical significant characteristics for a structure, building, site, or object that we may wish to preserve the integrity of. Being old doesn't automatically make a property historic, but it's part of what we consider as we make our initial review of properties. Typically, a historic property is over 45 years old, but this is not a requirement. A district, building, structure, site, or object may be deemed significant and listed in the National Register although newly constructed. For example, hypothetically, a newly constructed statue or museum that represents a historically significant object or place could be approved for listing and become protected under the National Register of Historic Places due to its historical or cultural significance regardless of its date of construction. Smash the like button for the YouTube algorithm. National Historic Landmarks, NHLs. The National Historic Landmarks, NHLs, are historic properties designated to require protection under NHPA and may include historic buildings, sites, structures, objects, and districts. There are over 2,600 National Historic Landmarks, NHLs, across the U.S. which are protected for their significance to American history and culture. The National Historic Preservation Act, NHPA, outlines federal agencies' responsibilities when their activities impact NHL properties. Section 106 of the NHPA requires agencies to consider the effects of their undertakings on historic properties, including NHLs. This means the agency must perform consultations with the regulator. Advisory Council on Historic Preservation, ACHP. The Advisory Council on Historic Preservation, ACHP, is an independent federal agency created under the NHPA to serve important functions which include involvement within the consultation processes for projects with adverse effects. They often serve as mediators when there are disputes with findings of effect, although disputes are not too common. The Advisory Council on Historic Preservation, ACHP, promotes preservation, enhancement, and sustainable use of the nation's diverse historic resources, and advises the President and Congress on national historic preservation policy. NHPA Section 106 gives the Advisory Council on Historic Preservation, ACHP, interested parties, and the public the chance to weigh in on matters before a final decision is made. When an agency is deemed to be in violation of NHPA Section 106 or seen to be doing actions that risk litigation, ACHP may interject themselves into the agency's Section 106 compliance per Section 800.9d. 2. To facilitate ensuring actions are in compliance for NHPA Section 106 ideally before the need of any actual suit being filed to lead the agency toward compliance and proper implementation of NHPA. If you want more information on NHPA, the ACHP website is a great resource for more information and training on NHPA. Adverse effect. NHPA Section 106 clarifies an adverse effect occurs when an undertaking harms the significant characteristics of a listed historic property. Characteristics that can cause an adverse effect include, but are not limited by the following: design, scale, and material. NHPA Section 106 intends to identify historic properties potentially affected by an undertaking, assess its effects, and seek ways to avoid, minimize, or mitigate any adverse effect to historic property. When there is no negative impact to historic property or no effect exists, it may not be subjected to further mitigation requirements or actions. NHPA Section 106 requires federal agencies to consider the impact that the action may have on historic properties. Federal agencies must consider the effects of their undertakings on historic properties and consult with State Historic Preservation Officers, SHPO, Tribal Historic Preservation Officer, THPO, Historic Preservation Officer, HPO, for United States Commonwealth territories and other stakeholders for project planning and implementation. Smash the like button for the YouTube algorithm. Consultations. For the National Historic Preservation Act, NHPA, we consult with the Historic Preservation Officers, specifically the State Historic Preservation Officer, SHPO, Tribal Historic Preservation Officer, THPO, Historic Preservation Officer, HPO, for United States Commonwealth territories. Coordination and consultation actions are required under NHPA for certain projects that have potential to affect historic property or resources. The NHPA required each state to establish a State Historic Preservation Office, SHPO, responsible for identifying and nominating properties to the National Register, reviewing federal projects for potential impacts on historic resources, fulfilling consultation regulatory actions, and administering historic preservation programs at the state level. Similarly, the Tribal Historic Preservation Officer, THPO, and Historic Preservation Officer, HPO, are applicable to tribal lands and Commonwealth areas. Public comment. Certain statutes and executive orders like National Historic Preservation Act, NHPA, National Environmental Policy Act, NEPA, Endangered Species Act, ESA, and Executive Order, EO 11988 Floodplain Management require projects to complete a timeframe allowing public comment within consultation processes to allow potential stakeholders, environmental groups, and the public to learn about the project and comment prior to actions occurring for the project. Smash the like button for the YouTube algorithm. State Historic Preservation Officers, SHPO. State Historic Preservation Officers, SHPO, administer state historic preservation programs and advise and assist federal, state, and local agencies or governments in carrying out their historic preservation responsibilities, to consult with them to ensure the project is in compliance with National Historic Preservation Act, NHPA. THPO. Tribal Historic Preservation Officers, THPO, administer tribal historic preservation programs and advise and assist federal, state, and local agencies or governments in carrying out historic preservation responsibilities, to consult with them to ensure the project is in compliance with National Historic Preservation Act, NHPA, for tribal areas. Tribal Historic Preservation Officer, THPO, administer tribal historic preservation programs and carry out the Section 106 process for tribal lands. For tribal lands, the State Historic Preservation Officer may not be involved because the Tribal Historic Preservation Officer has tribal sovereignty for overseeing these projects. The THPO and SHPO can always coordinate with each other on an as-needed basis. Even when a project is not specifically on tribal lands, the THPO may have interest in a project area and become involved in a project. This is particularly applicable to archaeological findings, which can have tribal significance, but be found outside of tribal lands. Ground-disturbing activities can uncover tribal culturally significant artifacts in non-tribal lands, for instance in areas that were once tribal lands long ago. Tribes may not occupy the lands today, but be indigenous to these lands and found in vast landscapes, even if not recognized as tribal lands today. Smash the like button for the YouTube algorithm. It is vitally important to ensure that tribal input is carefully considered throughout the formulation to implementation of project actions. When coordinating with tribes and the THPO, one must also be very understanding of varying communication styles, traditions, and cultural dynamics that may become applicable throughout a project. It is best to be knowledgeable of the many tribes in the area to ensure most effective outcomes and ensure positive, respectful interactions throughout every stage of a project. Historic Preservation Officer, HPO. Historic Preservation Officers, HPO, administer historic preservation programs and advise and assist federal, state, and local agencies or governments in carrying out historic preservation responsibilities, to consult with them to ensure the project is in compliance with National Historic Preservation Act, NHPA, for Commonwealth areas. For example, Commonwealth areas include the District of Columbia, Puerto Rico, American Samoa, the Virgin Islands, Guam, the Commonwealth of the Northern Mariana Islands, Republic of Palau, Republic of Marshall Islands, and Federated States of Micronesia, as well as others, all of which have historic preservation offices that perform similar duties to fulfill the requirements under the National Historic Preservation Act, NHPA. Feel free to check out Level Up with Alyssa Mahan YouTube channel to level up your life in a personalized way. See you there. Memorandum of Agreement, MOA. The federal agency may form a project-specific Memorandum of Agreement, MOA, with the SHPO, THPO, and /or HPO that outlines the agreed-upon treatment measures. The federal agency funding the project or action is responsible for ensuring compliance with NHPA and coordination with the SHPO, THPO, and /or HPO for actions pertaining to historic property. Smash the like button for the YouTube algorithm. Programmatic Agreement, PA. Agencies may coordinate with the regulator to gain programmatic agreement approval, so they may execute certain actions with pre-approval by the regulator under the agreement. The programmatic agreement is intended to reduce administratively timely processes for repeated actions that an agency may carry out in an approved manner based on prior approval of mitigative actions that were determined to not cause a significant impact with the implementation of measures described in the agreement, if any. Programmatic agreements allow for a more streamlined review process for implementing NHPA Section 106. The federal agency forms the programmatic agreement in consultation with the regulator. FEMA is probably among the most effective agency at implementing environmental and historic preservation statutes, regulations, policies, executive orders, guidances, etc., because billions of dollars flow through FEMA to provide funding for emergency preventative actions as well as disaster response and recovery actions post-natural disasters. FEMA has compliance reviews down to a science and meticulously trained staff to ensure compliance for projects. FEMA forms Memorandum of Agreement and programmatic agreements to facilitate more effective, smooth, timely compliance actions. My recommendation is for agencies to consult with the regulator to see if a MOA or PA is feasible for your mission and programs. The MOA or PA may exclude the review of routine activities from SHPO, THPO, and /or HPO review and shorten timeframes for review by the SHPO, THPO, and /or HPO because these actions were pre-approved to be implemented a certain way within the agreement. For example, the programmatic agreement may be executed prior to a disaster event occurring and may address state-specific needs and resources. Smash the like button for the YouTube algorithm. FEMA consults with the SHPO, THPO, and HPO to form and gain approval of programmatic agreements, PA, that we to administratively streamline and more effectively process projects that have similar scopes of work and historic concerns. Often the programmatic agreements describes review exceptions for properties under 45 years old. Regardless of the age of the property, we must ensure the property is not designated as historically significant by being listed on the National Register of Historic Places or National Historic Landmark lists. When a property is historic or culturally significant, the characteristics of the property must be preserved and the integrity of the property must be maintained. Subscribe by clicking on my on-screen photo. We will help you level up your successes and foster the best outcomes in life. Programmatic allowances. Statewide programmatic agreements, PA, list and summarize actions and activities that trigger Section 106 reviews as well as clarify programmatic allowances approved by the regulator to be exempt from consultation processes as long as predetermined treatment measures and conditions are implemented by the agency for the activities. Programmatic allowances for activities exempt from the consultation process with conditions placed by the regulator to offset impacts due to their potential to impact resources. The agency here avoids consultation processes, but is required to implement predetermined conditions that are placed on the activities. For NHPA compliance, FEMA implements regulator-approved programmatic allowances that aid FEMA in processing compliance reviews and project actions. Programmatic allowances help FEMA assess and implement treatment measures for projects and streamline initiatives that have no potential to affect historic properties, i.e. administrative actions. Consultations are to assess potential impacts and seek ways to avoid, minimize, or mitigate adverse effects on historic properties. Agencies should consult with the regulator to gain approval of Memorandum of Agreement, MOA, programmatic agreements, PA, and programmatic allowances to see whether they are feasible for their project, program, disaster, and/or missions. Level up your life. Follow us on Medium to unlock our secrets. Subscribe to us on YouTube. Case studies. Citizens to Preserve Overton Park v. Volpe, 1971. Landmark case involved the proposed construction of a highway Interstate 40 through Overton Park, a historic urban park in Memphis, Tennessee. This case applied the Department of Transportation Act of 1966 and the Federal Aid Highway Act of 1968, as well as resulted in a landmark decision that establishes a significant new legal principle that substantially changes the interpretation of existing law because it was set to precedent that the acts prohibited the Secretary from financing interstate construction through public parks if a feasible and prudent alternative route existed. If no alternative route was found, the construction could proceed through the park only if all possible planning to minimize harm had been conducted. Similar to the intent of NHPA, treatment measures to avoid, minimize, or mitigate impact to historic property must be approved by the regulator within a consultation process if an alternative route that causes no effect is not found. Concerned citizens and organizations challenge the project under the NHPA Section 4F, which protects historic sites and parks from federal transportation projects that would harm the integrity of the listed park. The Supreme Court ruled in favor of the citizens, affirming the importance of protecting historic sites under the NHPA and set a precedent for judicial review of federal actions that impact listed sites. Penn Central Transportation Company v. New York City, 1978, case involved the owners of Grand Central Terminal in New York City who challenged a city ordinance that restricted certain types of development on the property due to its designation as a historic landmark. The Supreme Court upheld the ordinance, stating that it did not constitute a taking under the Fifth Amendment's Takings Clause. The decision affirmed the authority of local governments to regulate development in historic districts and landmarks to preserve historic and cultural heritage under the NHPA. The decision affirmed the authority of local governments to regulate development in historic districts and landmarks, balancing preservation with property rights. Smash the like button for the YouTube algorithm. Friends of the Earth vs. Laidlaw Environmental Services, 2000, case involved a citizen suit brought under the Clean Water Act against a company operating a wastewater treatment facility. The plaintiffs argued that the facility's discharges violated NHPA and caused harm to a nearby river, which was listed on the National Register of Historic Places. Laidlaw Environmental Services Incorporated owned a wastewater treatment plant and was granted a National Pollutant Discharge Elimination System (NPDES) permit. The permit allowed Laidlaw to discharge treated water while limiting pollutants. However, Laidlaw repeatedly exceeded the mercury discharge limit set by the permit into the North Tyger River. The court ruled in favor of the plaintiffs, emphasizing the importance of protecting historic resources from environmental degradation and holding the defendant accountable for pollution that threatened the integrity of the historic site. This case demonstrates the interplay required between other environmental laws and the implementation of NHPA historic preservation efforts. Comment level up to show you are ready to level up and watch this video to the end. Conclusion. Overall, the National Historic Preservation Act, NHPA, enacted intents to preserve and safeguard historic resources. The National Register of Historic Places, NRHP, inventories districts, sites, buildings, structures, and objects significant in American history, architecture, archaeology, engineering, and culture that are to be preserved. The Section 106 review process ensures federal agencies consider the effects of their activities on historic properties listed or eligible for listing on the National Register of Historic Places, NRHP. Section 110 requires all federal agencies to establish their own historic preservation programs for identifying, evaluating, and protecting historic properties. The Advisory Council on Historic Preservation is an independent federal agency that advises the President, Congress, and federal agencies on historic preservation to help all fulfill the intent of the National Historic Preservation Act. Comment below. Do you have any questions about NHPA? Do you agree that we should preserve the historic characteristics of districts, sites, buildings, structures, and even objects? Yes, objects. Comment below. What is the weirdest object or NHPA listing you have ever seen? Send us photos in the comments for your favorite protected historic property. Let's see if we can discover some interesting ones in the chat. Tell us about your favorites below. Please do like, share, subscribe, and comment below to help support this channel and help me succeed so I can post more for you. Thank you all for joining me. Talk to you soon on the next one. Click on the on-screen images to subscribe and watch more videos.